Welcome to this new episode by public demand. Since Court Helicopter News started, very many of you have written your comments. You have asked questions. How can Court Helicopter be answering individual questions? This episode starts this first Sunday, and it will be every Sunday. We shall be dealing with questions that you have raised, and we answer them live. So today will be the first one. My name is Wakili Danstan Omari, the co-host, the person, the one who has done the research, got these questions, and will be asking with me is none other than Wakili in the making, Abedi Nego Matogo, together with the team of Court Helicopter, Vivian, Bramwell, and Sarah's. We have this interactive question where we'll be now engaging you so that you get to get your answers. Let us hear. Your name will be mentioned, if your location will be mentioned where you are, and the question will be answered. Mato, the floor is yours.
Thank you very much, Counsel. So the first question is from Ezekiel Rono, and Ezekiel Rono is wondering what happens for an employer who works for so many years yet they are not confirmed as permanent. And he's wondering, is it only in government where someone can be confirmed as being a permanent employer, or also in private practice?
Thank you very much. Originally, the law has been shifting very fast. The question of probation, the law provides for 6 months. Unless the parties agree by consent, after the expiry of 6 months, you are supposed to be confirmed as a permanent employee. But by consent, it can be extended to a maximum of 1 year. Remember, probationary employment can be terminated, and the courts have reported that you can still get the benefits like an ordinary employee. So, government question, is government now going to have employees permanent? Probation was heading to permanent employment. Government policy guidelines that came out last week is that they now want to put permanent and pensionable employees on contracts. The UN, there's nothing called a permanent employee. It is on contract. On private sector, there is nothing called a permanent and pensionable employee. It is a contract. We are now going into an era of performance-based approach where you are recruited for a specific task, for a specific duration. If the needs, then you are extended.
Thank you very much. There is another viewer called Harris Angaya. Harris is wondering, why is it that some private companies do not guarantee their employees off days? For instance, she gives an instance where, according to labor laws, is it lawful, Harris is asking, is it lawful that an employer should be deducted? Now that is the first limb of the question. Then she goes ahead to ask, is it lawful that an employer should deduct salary from an employee for asking for a day off, for off days? Sorry.
The first aspect is that every employee is entitled to rest 1 day. The law talks of you work for 6 days and 1 day is a rest day. That is by the law. If you are being worked for 7 days, it is illegal, it is not accepted. You seek your lawyer and you sue for being worked for 7 days. That 1 day is supposed to be paid for. That's why if you rest on Saturday, if you rest on Sunday, still your salary is for 30 days. Number 2, you have asked Harris, if you want to go on one off, you've lost a relative, you are unwell, 1 day off, are you supposed to be deducted your salary. We've done that explainer yesterday. The answer is simple. You are allowed 7 days leave with pay. That's the law. Any day you are off, you have 7 days of leave with pay. But you must produce a medical cheat where allowing you to be off. If it is being bereaved, we have the compassionate leave, you'll go. If after 7 days you have not resumed, the law says you can again be given another 7 days of half pay. After that 7 days plus the 7 days is 14 days, then you will go for leave that is called unpaid leave. So Harriet, now you know the law. Thank you.
Very well answered, Counsel. There is another one called Geoffrey Wabire. Geoffrey Wabire is asking you to elaborate on deductions that are made by employers for remission to SHA and NSSF, but they are not made.
We have provided that explainer. It's called who?
Geoffrey Wabire.
Geoffrey Wabire. The answer is so simple. Any employer who does not remit the deductions commits a criminal offence and will be fined a fine of 100,000 shillings or imprisonment for 6 months, and also he will be compelled to remit the money. That is restorative justice. So ensure it's your duty, and it's every employer's duty, every employee's duty to check whether your deductions are being remitted to your SACCO, to your NSSF, to SHA, and to all statutory areas. If they don't, then you can go to court to compel them to go to remit that money. Thank you, Wabire, for being candid and close.
Another follower and viewer called Douglas Nyakundi follows up with a question and asks, can an employee request that they be refunded their remissions before retirement?
The NSSF Act that came into place 2025-2026 provides that you can only be refunded after reaching 55 years. You cannot be refunded before 55 years. But the final retirement benefits will be given to you at 60 years. The reason why this is like this, the money you are saving is not money for today. It is money for an social security fund after retire. So this money is for your saving. The day you retire from any work, you have something, because you cease being active and you have got to feed, you have got to pay rent, you have got to take yourself to hospital and those issues. So until 55, that's when you'll be required to take that money.
Thank you very much. Joseph Kule asks on a different limb, what about working in an organization and you're paid less? So he's probably asking about contract payment.
It depends on the contract, Joseph, that you have. The freedom of negotiation, both of you will be doing the same job. But if you didn't bargain for your salary harder, your employer will be giving one this, the other this. Unlike government that pays based on the grade you are. In government, if you're in this grade, your salary is fixed by statute. But in private sector, you negotiate. So my advice is that you negotiate based on what skill are you bringing to that entity. What value addition are you bringing to that entity? It is performance based. And that is why the private sector has nothing called permanent and pensionable. If you don't deliver the targets of the boss, you go. If you deliver, you ask for bonuses. If you deliver, you can get 4-5 times a salary increment. If you are a deadwood, nobody will retain you. So, Joseph, work hard, negotiate hard, or move further. Your salary depends on what your output is.
Correct. Very well put. Jacob Ombaka asks, What would you advise in instances where civil servants' phone numbers are shared out on social media platforms by Shylocks?
Ombaka, anytime you see your personal data or anybody's personal data shared, it is against the Data Protection Act. It is criminal. It can also be civil. There is the Data Commission, the Tribunal for Data, where it is mandated to enforce data privacy. Data privacy, personal privacy, are protected under Article 31 of the Constitution. The inherent dignity of a person is provided for in Article 28 of the Constitution. So if anybody has been, his phone has been shared by Shylocks, get in touch with us or immediately make a complaint to the Data Protection Tribunal for 5 million shillings. That is money that you'll get.
Thank you. Godfrey Kariuki raises a question where he has been denied his tax compliance certificate for remissions not made between 2016 and 2018 by his employer. He seeks your advice.
The avenue is there. You get a lawyer to do a demand letter for the employer to forward the tax deductions. If they doesn't, you sue that employer, and the fine will be, he will be ordered to remit the money he deducted to KRA. 2, he will be fined a fine of 100,000 shillings and or both a fine and imprisonment to 6 months.
Very well. Then we have a Jimmy Wagetha. Jimmy requests that you advise on the maximum working hours of an employee.
Jimmy, the maximum working hours as provided by law is 8 hours. Any work done after 8 hours is called overtime. So, overtime, whenever you work more than 8 hours, overtime is paid hourly, double the price of an hour you work when you are working during the day. There are those, so in a day we have 3 shifts. For example, in hospitals you'll have 3 shifts. In bakeries, in factories, we'll have 3 shifts. But most of them, if they want to have 12 hours shift, then they must pay that overtime all the time. And most of the employees rarely are paid for overtime. When you go to the labor court, those are some of the issues that you raise, and you find that you calculate all the number of days or hours that you worked for overtime and you're paid.
So we proceed to Evans Amenya, who requests that you put in your insight on an employee being denied their day of worship. For instance, they worship on Sunday, but they are denied. They are compelled to be at work on that day.
We have done a case just now, Amenya, where we are saying the SDA, the hospital refused an SDA worshipper to attend church on Saturday, and the court found out that that is an infringement of the right of religion as provided for in Article 32 of the Constitution, and therefore the freedom for worship cannot be curtailed. Under Article 24, it provides for when the rights of a person can be curtailed. Therefore, that is illegal and unconstitutional. Move to court, and the courts will protect your right. The right to worship, a day of worship. And that is why the law says you have 6 working days. 1 is your worship day. Thank you.
Very well. We have another viewer called Stefil. Stefil requests that you put some insight on serious injuries that are sustained during the normal working hours of an employee, and how much compensation they can seek.
That is Stefil. Stefil, thank you very much. We know there are occupational hazards. Everywhere, working places can be a risk to your life, to your body, to your health, to everywhere. The Workmen's Compensation Act provides for what to be paid. That is the next episode we shall be dealing with under the WIP, what amount can be paid. But any injury occasioned by the employer, if he has not provided an employment mechanism, then he or she will be held liable. But also, there is also the vicarious liability issue. Are you yourself responsible for the injury? Have you come yourself drunk to the factory, to the working place, and because you are drunk, you are not able to manage the machines and you are injured? We'll deal with that in the next episode. Thank you very much.
Absolutely. We have a Kipkoech Roni, one of our viewers as well. Kipkoech requests that you highlight what he can do or what a normal employee can do in the event their accounts are frozen and their salary is not remitted by a former employer.
The only person who can freeze an account is the Central Bank of Kenya or the court of law. The DCI normally goes to court to get an order to freeze an account. An account is a personal relationship, a contract between the account holder and the bank. Unless there is fraud and unless there is anything, banks have no authority to flag an account. But the Financial Reporting Center, which is a branch of the Central Bank of Kenya, has the responsibility if unexplained money, huge amounts of money, are found into an account that has not been transacting huge amounts of money. Your account per month handles 200 shillings. All of a sudden, that's for around 10 years. All of a sudden, there is 20 million shillings in that account. That bank has a duty to inform the Financial Reporting Center. But an employer or an employee has no capacity. That's the employer has no legal capacity to freeze an account of a former employee.
Very well. Lastly, we have Tomio Opande.
Yes, Tomio.
Tomio asks that you highlight on what should be done when employees are put to work for long hours and overtime and no holiday payments.
That is what we call forced labor. Under the Constitution, slavery and forced labor is prohibited. Any work must be done within 8 hours. Any extra work is called overtime. It must be agreed and the payment is double. Third, any work done 7 days without a rest is illegal unless there is agreement. If there is a way the employee is going to be compensated for working 7 days, that is an agreement. If it's not there, that is illegal, and that is an issue, one, that should be raised by the officers called labor officers under the State Department of Labor, and also by your lawyers heading to court to get that remedy done.
Very well. I think most of the questions we have covered, save for those ones which we have answered in the midst of answering others. But we thank the viewers, the questioners, and we ask that you continue asking your questions and they will be accurately and acutely responded to. We thank you.
Thank you very much. And as we said, this is a pioneer group, a pioneer episode. Every Sunday we shall be answering questions that come up the whole week. Thank you. We appreciate. Keep watching Court Helicopter News. Every time we are innovating, we are improving, because we have a customer care desk that deals with your issues, deals with your sentiments, and will respond appropriately. Thank you. From Court Helicopter News, Wakili Danstan Omari.